We have a very full panel today joining us on stage as well as online. Our moderator for this panel is Dr. Jamsheed Peeroo, Bar of England and Wales and the Mauritian Bar as well. And our panelists are Advocate Svetlana Vasileva, Dr. Henry Murigi, Dr. Dalia Hussein, Victor Mugabe, Karim Mziani, Guilaume Tattevin, Korinna von Trotha, Advocate Henk Louw, Dr. Aleksei Korachkin, as well as Dr. Nyanje, or rather John Nyanje. Ladies and gentlemen, a warm welcome to our moderator as well as our panelists.
Good afternoon, everyone, and thank you for the kind introduction. The panel title is Collaborating for Credibility, Institutional Cooperation, and the Future of Arbitration in Africa. So as the title suggests, this session will explore how meaningful institutional cooperation can strengthen credibility and also the development and therefore a global integration of arbitration across the African continent and beyond. And also how this can be achieved through shared standards, which are extremely important, but also through practical means such as joint initiatives and regional networks, because credibility indeed is extremely important. In other words, having trust in arbitration as mode of dispute resolution. And that trust or credibility is fundamental, not only for the users, but also those who hold themselves out as serving the users, namely the institutions. And we are therefore privileged to have esteemed representatives from leading arbitration institutions from Africa and beyond on this panel to discuss this very important topic. And I should say, in fact, I should congratulate AFSA. I think this is the first time we have such a wide representation of institutions in a panel on the African continent, and such a diverse panel indeed. So well done, especially to Svetlana and also Liz Bossman and everyone at AFSA for having taken this initiative. Now, let's dive directly into the topic. Let's start by setting out the current state of affairs. As we've seen, MOUs are being signed, and this has been the case for many years. I will assume that all the institutions represented have some sort of cooperation with other institutions. So let's start with perhaps exploring that. What does the scope of cooperation typically cover when it comes to cooperation between institutions? And maybe Karim can start by saying a few words on this point about the scope.
Absolutely, Jamsheed, and thank you very much again for the invitation on this panel. So regarding the scope of cooperation between institutions, the Permanent Court of Arbitration that I'm representing here today thought about exploring avenues with arbitral institutions around the world, but not only around the world, also and specifically for today in Africa. And the goal was to, first of all, build, to have capacity building and trainings, because there was a demand from stakeholders to have more trainings, to be more experienced, and also to know exactly how to administer and handle cases with the best international standards. So that was one aspect that was covered in Memorandum of Understandings. Then something that was also included in MOUs was drafting of arbitration rules and mediation rules. Something that we discovered is that whenever there is a new institution in one country, they obviously have to create their own arbitration rules, and therefore they needed support for this. So the Permanent Court of Arbitration, together with the local institution, worked together to make sure that they would be able to provide the best rules and also to comply with the new request from parties in arbitral proceedings and also mediation proceedings, because now you are aware that there is a demand for expedited procedure, for example, and this is something that is more often included in arbitration rules. And finally, not to maybe say too much, but just to keep everything in a nutshell, there is also the design of hearing facilities, because you're also aware that there's a need for hybrid hearings. So obviously, any facilities must be modern, with inbuilt camera system, with AVIT that is already present, instead of relying on external service providers. This can already be in the hearing facilities. Organization of hearings is obviously something that is requested. And finally, and most importantly, exchange of expertise. Because you want to know how you conduct proceedings. You also want to know how appointment of arbitrators or appointment of mediators are made. And therefore here, the PC expertise is something that can be shared with the arbitral institution that request it. I may use one example that I will then develop further, but the Permanent Court of Arbitration currently has a cooperation agreement, and its strongest one is with the Mauritius International Arbitration Centre, and I serve as the Registrar of MIAC, the Mauritius International Arbitration Centre, and here there's also a transfer of human resources and human power to ensure that MIAC can serve the community, and in particular the arbitral community, at the best level. And finally, something that is covered not only with arbitral institution but with the arbitral community in general is the training and courses given to local universities. And here I would like to maybe highlight the role of Liz Bosman, who is the president of AFSA International Court and is also a professor at the University of Cape Town. And she, with the PCA, has developed the LLM program in which PCA legal counsel intervene for LLM and LLB students. So I will just keep this here, and I can develop further afterwards.
Thank you, Karim, for setting this in so usefully. So I understand that the scope of cooperation is quite far-reaching, isn't it? And I believe on this question, maybe Henry, who is online, Dr. Henry Murigi, who is the CEO of the Nairobi Center for International Arbitration. Yes. Henry, did you have something to add to what Karim said?
Yeah, thank you so much. And I want to thank the organizers of this great event and say that in addition to what my co-panelist has said, we can see also intercontinental areas of convergence between institutions. For example, if you look at the Africa-Asia Legal Consultative Group and also the organization that informed the need to create institutions such as NCIA, it was brought out from cooperation between states that then thought it is important to establish institutions. And now, once the institutions are established, they have two options. The first option is to collaborate with other institutions and then grow the reach of what the objectives are. So I think capacity building is something that we would see in typical MOUs, institutional networking, visibility. Of course, also area of technology is a big one, and also development of rules, partnership in terms of standards, creating of standards. And at this point, I also want to mention a few, Liz Bosman, we had a webinar the other day about looking at how NCIA rules look like and trying to see what then that would look like in comparison with other leading institutions. So there's a lot of collaboration around exchanging of ideas and best practices. And I must say that this is a much better approach compared to a more, interest power-driven approach of institutions that seeks to dominate and, extend their influence all over instead of collaborating and working together with a view to growing the space of ADR, especially in the continent of Africa. That's what I can say, sir. Thank you.
Thank you, Henry. That's very helpful insight. I will move to a more perhaps controversial topic, as everyone who know me know I like to do. There are many MOUs, but are they lying deep under a pile of other MOUs in a drawer, or are they being implemented and actually performed? And if they are, how? And if they're not, why not? So I'll ask John to start on this, if you can.
Yeah. Thank you very much, Jamsheed. I think it's a very important question because it's normally the question you get every time you try to sign an MOU, what happens next, because there's a lot of them that have been signed. So I'll give, for example, the cooperation that we have with some of the institutions in this panel. When we tried to first sign it, everyone said, what happens next? And what was required was for us to put some measures to see that it goes forward. So I think the reason why most of them don't do very well is because there is no KPI behind the signing. It's a ceremony for the signing, and sometimes it serves a dual purpose. So arbitration institutions also do, part of the big business is marketing. And sometimes that event of the signing is already a KPI for the arbitration institution and nothing beyond that. So I think the most important part for them to work would, of course, require deeper checking into what is to be achieved and what are the targets immediately after that signing. That is a very important aspect of why those MOUs sometimes don't work, because there is no framework of what are we going to do immediately after the signing. And secondly, I also think the MOUs don't go very far to what is required. So for an MOU to work, you would need a dedication of human resources, of sometimes, asset resources and all that. And most of the time it's not explained very well where it will come from, who will dedicate to do what, from which institutions. And also institutions sometimes, are also understaffed. How much more can they give? And I think that's also another big problem. That's why many MOUs don't tend to work, because there's no agreement on how the progress and the program would carry on. And lastly, I also think it's just a lack of accountability sometimes on the part. And I think the stakeholders in arbitral institutions need to start making demands on whether an MOU works or not. So a good example is the AFGAC, for example, the African German Arbitration Corporation. The first 3 years got funding from the German government. And that funding from the German government had to be accounted for each and every single thing that the MOU was going to work. So you were not going to sit on the money and do nothing about it, because then you have a problem, because it should have been awarded to somebody else. But secondly, if you do something, there's somebody asking, this and this is agreed on the corporation, and what are you going to do about it? And so I think the stakeholders and the board members at the arbitration institutions level need to ask questions about these MOUs, because if you're spending, even if it's human resource time or otherwise, there should be some kind of accountability towards why the corporation is not working, or what are the hurdles for it. So,
very helpful. Thank you. Thank you very much, John, for giving a perspective. And I believe that's the perspective of the institution you represent, which is Africa Germany Arbitration Corporation as well. Let me ask, please ask Aleksei, Dr. Aleksei Korachkin, who is the chairperson of the Arbitration Chamber of Belarus, and who unfortunately could not get here, so he's joined us online. He is on the screen. Aleksei, would you like to share your views?
Yeah, thank you, Jamsheed. I hope you see and hear me well.
Yes, we can.
First of all, let me warmly thank the AFSA and warmly greet AFSA and all participants from Belarus. And it's a great honor and a privilege for me to be on this panel along with other distinguished speakers. Concerning the MOUs and its implementation, the Chamber of Arbitrators try our best to really implement and actually perform all the MOUs that we are signed. And in this regard, I want to firstly consider the goals of signing MOUs. An MOU should offer advantages for arbitral institutions and, more importantly, for their users, for disputing parties. In my opinion, there are some possible goals for signing MOUs, and the most crucial of them are legal education. It's jointly conducting webinars, conferences, and training courses. The second possible goal is bringing expertise to dispute resolution boards. In my opinion, for users, it's easier to include specific arbitration rules in arbitration clause if we know what in the panel of arbitrators there are experts who not only have broad experience and knowledge in a particular field, but also understand the business mindset and cultural nuances of how parties from other parts of the world conclude and implement contracts. And the third possible goal is facilitation of dispute resolution process, providing venues for disputing parties, mutual use of electronic platforms for secure dispute resolution, and administering arbitration under cross-institutional rules. So users can choose the rules they prefer while benefiting from lower arbitration fees or a more accessible and convenient venues. For example, business cooperations between Belarus and China nowadays are growing significantly, and the Chamber of Arbitrators in this regard provides users with the possibility to include in their arbitration clauses the rules of Guangzhou Arbitration Commission, but with administration by the Chamber of Arbitrators under our arbitration fees at our venues and using our panel of arbitrators, which includes approximately 20 Chinese arbitrators nowadays. A similar approach can be seen in the Tashkent International Arbitration Centre and Hong Kong International Arbitration Centre cross international rules. As far as I know, there are several major infrastructure projects nowadays worth over $1 billion what use the TIAC HKIAC arbitration clause. So to sum up, we make a lot of efforts in order to implement and actually perform our MOUs. Thank you.
Thank you, Aleksei, for sharing your insight, especially from that part of the world, and I'm sure the audience and the African institutions here and on the panel value this comment. And I'm very grateful. Now, let me, because it's the controversial question, I want as many speakers as possible to say their views. So I will now ask Korinna von Trotha, who is the Executive Director of the Swiss Arbitration Centre. What are your views, Korinna?
Thank you. And good afternoon, everyone. I'm sorry for not being in Johannesburg today. At least the sun would be shining, I think. On this controversial topic, when I started my career in institutions, I was also quite suspicious about these cooperation agreements because I often felt that they actually end up in the drawer, as you just mentioned. But having signed around 15 arbitration agreements over the last couple of years here with the Swiss Arbitration Centre and the Swiss Arbitration Association, I've slightly changed or varied my views on them. From my experience, more than half of them are actually quite active. So I think it is worth trying and worth accepting requests for cooperation agreements and keeping an open mind for requests. On the other hand, I think cooperation agreements are not a must to otherwise collaborate. There are so many ways of engaging with other institutions or other stakeholders in the field for which you certainly don't need a cooperation agreement. So very often, I also take the approach to actually tell institutions who would like to cooperate with Swiss institutions that we should first do something together and see how we can collaborate and then enter into an MOU, for example. So different ways of how we cooperate, whether we have a cooperation agreement or not, are obviously events. So we have ad hoc or let's say one-off events with a number of institutions, arbitral institutions. Some of them are really very popular. For example, the ASA practice seminar. We do them once or twice a year with different arbitral institutions out there, especially the ones outside Europe, are very popular. And it's a great way of cooperating with other institutions. But sometimes it's just a one-off event on a specific topic, and then, as we did, for example, collaborate with the Japan Arbitration Association in Tokyo for the Japan Arbitration Week. We co-hosted the event, and that was a great success, and I think support for JAA as well. Besides that, I wanted to mention that there is also IFCAI, the International Federation of Commercial Arbitration Institutions, of which I'm a council member. IFCAI itself has around 50 members, commercial arbitration institutions. And this is a great network, and I can only invite as many arbitral institutions with an ongoing case management practice or other established activities to join IFCAI. This is obviously also quite a formal way of collaborating with other institutions. In my view, the very important way of collaborating is actually in informal settings. So I have a lot of bilateral exchanges on the leadership level with other institutions on different topics. It can be technical, it can, I mean, everything that's going on in the AI world and how you need to revamp your institutions to actually manage all those new technological challenges. But it can also be on the secretariat's level, meaning that the legal counsel who manage cases can actually exchange with their peers in other arbitral institutions and discuss the common issues that they face in their work. So I can only strongly encourage this bilateral and also informal exchange between institutions. Thank you very much.
That's extremely helpful, Korinna. Thank you very much. And so even as a practitioner, I mean, we always value the possibility of discussing with a colleague who might not be involved in a case. So I suppose this is what Korinna was saying in relation to institutions, and it makes perfect sense. Henk, who requires no introduction here in South Africa, what are your views?
Thank you. Representing the Chartered Institute of Arbitrators puts me in a fairly unique position in that we're part of a global brotherhood and sisterhood of branches. 8 in Africa, 44 globally, representing 18,000 practitioners, dispute resolution practitioners over the world. So from that perspective, internally within the Chartered Institute, it's not always necessary to have cooperation agreements because we have that massive network where we look after each other. And I echo a lot of what Korinna has said today. We don't always need these agreements. And once we have the agreements, I often found that it goes onto the bookshelf or into the drawer. People want to act in terms of it, and often there's a more one-way street of cooperation, in that the other institution may often require more, and it's an improper flow. What I've also found in the process is that some institutions are protective of their stock and trade, and the stock and trade is, of course, the dispute agreements, and those that resolve the disputes. So there is to agree sometimes a resistance. But if we run in the informal manner of cooperation that Korinna has referred to, here we are sitting today, and I don't know if you've looked at the stats of what we have today. We have England and Wales here, we have South Africa, Kenya, Cairo, Nairobi, Mauritius, Switzerland, Belarus, and so it goes on. And if we take that with the Chartered Institute's footprint, we're sitting with 75% of the countries on the globe are represented here on the stage today. And that's a wonderful way of looking at these things, and we can do everything that we need to do, not necessarily formally by way of memorandums, but informally through the networks that we've created here today. That being said, I think cooperation between the parties and going forward and dealing with each other formally or informally is massively important. But take into consideration that there are areas in which there may be institutional caution as to the disputes, those who they have to put into the disputes and resolve the disputes. So yeah, it happens, but not all the way. Thank you.
Thank you, Henk. And that's very helpful indeed, because my next question would be to ask the panelists to perhaps illustrate how under an MOU practical problems can be solved. And perhaps to do that, the best way would be to ask one or two panelists to identify practical difficulties faced by institutions, and then see how MOUs or other means of cooperation have managed to solve them. So let me put this question first to Svetlana. What are practical difficulties faced currently by AFSA?
From AFSA perspective, these recurring practical difficulties we are facing in our everyday work on the ground, on the first place is the tension between ad hoc and institutional arbitration. And in practice, choosing between the two of them means stepping away from the familiar habits and the comfort zone many of the practitioners they have. But many, especially from the domestic users, still perceive ad hoc proceedings to offer greater control, more flexibility, and lower cost. And we know this is not always the case. And perception, but all of that, the perception still remain deeply rooted in our everyday life. So the issue for institution is not to continue to convince the market in some abstract terms, but to demonstrate that real value of institutional arbitration. What institutional arbitration gives in addition in managing, for instance, the timelines, supervising the due process, and reducing the risk around the enforcement of the award. So from AFSA Secretariat perspective, what we try to do is to provide flexible support and administration, something that in ad hoc don't have it. And, but not light touch approach is the flexible one. So we are involved in any step of administration of the case. And we're supporting the party and the arbitrator. So it's not the question of, I think it's not the question ad hoc versus institutional arbitration. Is about whether the perceived advantage of one or other one need to be used in a proper way. And the second things that we, or difficulties or challenge that we face is bridging domestic with international practices. And this also leads to the party and arbitrator behavior and that growing tension between efficiency and over procedure. I cannot get right that word. Proceduration. So, but in other words, and we talk briefly with Dalia in Cairo, they face different challenges, and it was interesting to see each of arbitration institution what they're facing. So I will leave to Dalia to share their challenges and to see how we can help each other.
That's very helpful. Yes, Dr. Dalia Hussein, who is director of the Cairo Centre for International Commercial Arbitration, CRCICA. Yes, Dalia, please share.
Thank you very much. I'd like first to thank AFSA for the great organization and for inviting me here, especially Svetlana. Thank you very much. Yes, it was interesting to see, discussing with colleagues, that we all face very similar problems on the ground. I'll just mention two examples. So conduct and this tension that is very clear. Conduct of parties and of arbitrators throughout the proceedings. So while the institution is pushing very much into efficiency, you have a lot of guerrilla tactics, delaying tactics, and suddenly, especially when it comes to pushing either the institution at the early stage or the arbitrators to accept last-minute claims, last-minute witnesses and documents, and after closing the proceedings, reopen the proceedings to get more documents and all the arguments about that. So this is really affecting the efficiency of the proceedings, and the institution finds itself sometimes what we can do to address that, especially with the due process paranoia and all. So this is one big problem. And the other one is very similar to the tension between ad hoc and institutional arbitration. We are facing a lot of pathological clauses, and what is bad about them is how they problem about how they state, how they mention the institution. And it is interesting because most of the institutions, if not all of them, have model arbitration clauses. It seems that nobody ever look at them. So we find we have a lot of cases where we have the International Centre for Arbitration in Egypt, or the Regional Centre for Arbitration in Cairo, and you have parties arguing. And we have a case right now that the claimant started the case arguing that this is an institutional case, please apply your rules. We did. Respondent came and said, no, CRCICA has no jurisdiction. However, we're still appointing our arbitrator, but you have no jurisdiction. Suddenly, claimant comes back and say, okay, let's deregister the case and please have it, register it as an ad hoc case that you're administering, which is okay. Then respondent come and say, but you know what, we never said that this was not institutional arbitration. This is institutional arbitration, but just not the CRCICA rules. And here it goes on. So there is this tension, unfortunately, between both of them. We'll see what the tribunal will say at the end of this.
Yeah, no, these are real challenges, which also remind me of certain cases. But yes, it's very, very useful to see how it's seen from the institutional perspective. I'll ask Guilaume Tattevin, who is a partner at Archipel and a court member of the Swiss Arbitration Centre. Guilaume, could you, feel free to add any further problems, but I see we have quite a few, but also turn to addressing any practical solutions to these problems, drawing from institutional experience and perhaps through cooperation if possible.
Thank you, Jamsheed, and thank you, AFSA, for inviting the Swiss Arbitration Centre. I think I would agree with the problems that have just been explained to us, and I'm not going to add other problems to that, but I'll offer perhaps a solution, which in my mind is institutional memory. in the sense that when problems arise, they are resolved, almost always, I mean always. And the purpose is that when the problem arises again, it's resolved perhaps faster or better. And in order to do this, the important thing is to communicate and ensure that you benefit from the memory of the arbitral institution. Now, the Swiss Arbitration Centre, under its various formats, has existed for a century and a half. And I'm not going to say that we have 150 years of institutional memory, but certainly the Centre does try to make sure that when a problem arises and it's dealt with, everyone knows about it. And speaking as a court member, for instance, we have regular court meetings where problematic cases, issues that arose are discussed, so that we can decide whether it was dealt with appropriately or could have been dealt with in a different way and how to address it in the future. Because it's the nature of these problems that they will resurface in the future. And I'm coming now perhaps to what you said about sharing, Jamsheed, and the MOUs and the sharing between institutions. But everything I've heard, I've seen as well. At the Swiss Arbitration Centre, almost everything that I've heard. So in order to improve on the institutional memory, or perhaps share the memories of the institutions, there is certainly, I think, a path to cooperation in order to ensure that what an institution has discovered is not lost for arbitration as a whole.
Thank you, Guilaume. But this is idealistic, I think, but it's an asset that every institution has that can be shared. But hopefully it's not the competition mind that comes to say, well, we have a perfect service or perfected service. Why would we share it with a younger institution? I don't know if someone, maybe Henry might want to discuss that from his perspective, or any other views of complete freedom. Henry, please.
Thank you. I just wanted to agree with my co-panelist and also just add that one of the other problems that you will find is when crafting these MOUs is, do you become very broad or very specific on a certain aspect of cooperation between whichever institution or entity you're cooperating with. Whichever option you take has its risks, has its opportunities. And may I say that every challenge or every problem always is, within it lies the solution and lies the opportunity for innovation and for creativity. And so to the topic of MOUs, I think there is a constant need for reviewing of the MOUs to see which is working, which isn't working. You can, for NCIA, for instance, we rework some of them and say, this one, let's focus much more on this area of collaboration that is then producing, for instance, more training for capacity building, or is producing more inroads into the younger generation of arbitrators. So we are looking more into that. And of course, also to consider basically retiring some of the MOUs that are basically not working. That's a perfect solution. Just say this wasn't going to work. The last thing I want to say on this is in the global uncertainty that we are in right now, where every 3 years there is a crisis coming up different from the other one before we even discover the solution for the other one. I think institutions need to think through how then do we adapt and reimagine how arbitration, for example, needs to look at. And I like the suggestion about informality. Some of these things don't require all the formalities that go into arbitration. And for example, for NCIA, we have sort of clear rules on how we incorporate and how we come up with an MOU, some of which sometimes may delay the execution of the MOU. So I really take on board the suggestion by the panelists that we consider really just saying we're working on this. And of course, was also what Korinna said, that look, let's try and plan an event together, and then if it works, see our synergies and then see how we could do about it. So I think those are some of the solutions to add on to what my companions have said. Thank you.
Thank you, Henry. Now, in addition to MOUs, we've spoken quite a bit about MOUs. Are there other, perhaps what the MOU should be saying the institutions should do, or they already do, but what are the practical mechanisms that should be put in place? For example, should there be regular meetings for the sharing of knowledge and experience, obviously in the ultimate interest of arbitration as a credible means, so all institutions, old or new, have a common interest to promote it. But concretely, practically, what has to be done? May I start with Karim on this?
So here maybe I'm going to make the comparison with everyone that is in the audience today. Arbitration is about the intention, and everyone has been intentional to come here to meet with others, to build profile, and to also make sure that you not only promote AFSA, and you're also here to know about AFSA, but also about Johannesburg as an arbitral seat, an arbitral city, but just the intention. And I feel that MOUs and beyond MOUs, it's all about the intention that you're trying to seek. And as a practical mechanism, for example, that I see at the Permanent Court of Arbitration, we are very intentional in the way that we want to promote other institutions with which we are working, either through an MOU or outside an MOU. One very basic example, we have parties that are requesting a hearing and they want to explore new venues, but they don't know where to go. We have MOUs across the continent, and then we're just saying, okay, why don't you go to Kigali? We have a cooperation with KIAC. Why don't you go to Nairobi? We also have a cooperation with them. What about Johannesburg? AFSA is also a collaborative institution with the PCA. So this is why intention is very key. And in addition to intention is also doing. But it's one thing to say and another one to do. And by doing, for example, the PCA is always very active in making sure that we're implementing MOUs, but we're also trying to do things that are just beyond MOUs. And here I'm just going to provide one example that may speak to everyone here today, is about trainings. So we talk a lot about trainings that we do all together as institutions, but we also provide trainings to practitioners, to arbitrators, and to experts. And by experts, in last March, in fact, we welcomed and hosted a training for Ethiopian experts. They were engineers, and they wanted to know exactly how they could benefit from our experience if they have to be witnesses in arbitral proceedings. And this is where I'm also saying about the intention and the doing, because they requested it and we did it.
Thank you, Karim. We are running out of time on this first part, but I will ask Victor to, obviously he could not make it, unfortunately, but Victor Mugabe is the Secretary General of the Kigali International Arbitration Centre, and I believe he is a familiar face here. Victor, any thoughts on what can be done practically?
Yeah, thank you very much, Jamsheed, and good afternoon to everyone. And as my colleague said, I just want to thank the AFSA and their leadership for actually organizing this very successful event and having invited KIAC to be part of the event. So on the topic, actually, I'm not going to add to, I think much to what my brother Karim from Mauritius have just said, because eventually, we all need to make sure that we conclude really fruitful and effective MOUs. So we think that in the most MOUs that we've signed, we realize that it's just ceremonial. But we forget to include something very important. I think there is need to include some kind of a very technical mechanic to assess the effectiveness of the MOUs and expected objective that we've just set. So I think that is really very, very important to establish a kind of monitoring and evaluation mechanism of the MOU that we have signed and to assess on a regular basis to see whether they are producing really the expected results. Secondly, there is one point that my colleague from Mauritius just said. We need to work in a kind of a transparent cooperation. So because what African Arbitration Centre are now lacking, I think, beyond our national jurisdiction is the trust by the users of the users of arbitration service out of the continent. So I think as long as we do cooperate, we still need kind of capacity development initiatives, but also investing in strategies and activities that really improve the efficiency of what we are doing as arbitration centers, but also the trust of our institutions. So that will be done through the promoting each of us here on the platform, but also with other African arbitration institutions that are said to be leading arbitration institutions. So to me, I think we still need the fruitful training and capacity building initiatives, but also recommending, potential clients, various cooperating regional arbitration institutions on the continent, but also we do have some technologies that we use in our respective jurisdictions. So I think it's very important for us to share the kind of technological mechanisms that we are using in one institution that we think can serve to other partner institutions. So I think that is very important because what we are doing here is, the intention is to provide a range of choices to the potential users of our arbitration service, so we could not really think of competing among ourselves. So I think those are kind of practical approaches that I would really want to recommend to ensure that we put in place a more practical collaboration, as we've started with AFGA in the AFGA framework that is represented on the platform of John Nyanje. I think really if you continue in that way, we can really become more proactive and build efficiency and trust among our arbitration institutions. Thank you.
Thank you, Victor, for this very useful reminder. We need to move on to the second part, but I'll allow John a very quick last word if you have anything on this point.
Yeah, I think for me, for a practical way to work, and AFGA might not be the best example because there was an extra help. So the question was, if the MOU doesn't work, what do we do? So what they did is they went and hired a third-party think tank. And the work of the think tank is to ensure the cooperation works.
Wow.
And that's one of the reasons maybe the cooperation has been very successful. I don't think we've ever missed a monthly meeting. I don't think we've ever missed our training programs that we put in place. We have a very wonderful website. You should go and check it after this, www.afgak.com and .org, sorry. And there you will find, the arbitrators list of these institutions. You will find the ways to get the cases on. But that requires a lot of work. It's not work you can leave for the institutions to do independently. And so I think if the institutions are able to get third parties whose work is to, like Karim was talking about, Henk was talking about, evaluate and see the progress and how it works, then that is important. And I think that has been the secret to how AFGA has operated.
Thank you very much, John. That's very, very helpful and a very practical solution indeed. Let me move swiftly to the second part of our discussion. I did give you an idea of the controversial issue, but now we're going to the main controversial issue, I think, because we are talking about credibility of arbitration, which is the credibility of arbitrators, arbitration practitioners, and arbitral institutions all combined. And our credibility of arbitration took a huge hit with the PNID against Nigeria case, which was a $11 billion award made by a majority of the arbitrators, 2 UK arbitrators, against the state of Nigeria. And the African arbitrator, who was appointed by Nigeria on the panel, gave a dissenting opinion. And Nigeria challenged this award before the High Court of England and Wales. And the English High Court was raised some serious criticism against the approach of the majority, the tribunal, but indirectly the majority tribunal in its decision-making process, because there were obvious red flags and no one bothered to investigate them, for instance. And this was in a very diplomatic way stated in the judgment. So, but when commentators, expert scholars started looking at this, I think, overwhelming impression, especially from the continent, was that there must have been some sort of unconscious bias somewhere, either against the African party or for the Western party, who won $11 billion and then had the award set aside. So it was a big hit to the credibility of international arbitration, and it's still talked about until today. And now that we have institutions on this panel who have the key function of selecting arbitrators, I have taken the opportunity to ask, the key point being that perhaps in PNID in Nigeria, if there was one UK arbitrator and one Nigerian arbitrator appointed by the party-appointed arbitrators, but the presiding arbitrator was from a completely neutral origin, background, from the West and Africa, then no one would have been able to say that there is unconscious bias in international arbitration, which is a big hit. So my first question to the institutions represented today is whether your institution is addressing that expectation, namely that the presiding or sole arbitrator should be perceived. And I wish to distinguish here, because you might know them personally and say, no, this person will not be biased. They have great reputation, integrity, which is known within the legal profession. But what about the users? They don't. So those sole or presiding arbitrators are expected to be perceived as being neutral, so that whichever way they decide, similar criticism cannot be made against arbitration again. And I should mention that PNID was not an institutional arbitration. It was an ad hoc arbitration, so no institution has any blame in that matter. Let me turn to Victor first. Victor, can you please tell us your institution's practice or perspective?
Yeah, thank you very much, Jamsheed. You're actually right. So this High Court decision on the Nigeria versus PNID, it's really influencing and making that most institutions and arbitral tribunals within institutional administered arbitration really do things. So for like the Kigali International Arbitration Centre, we really took that decision very seriously. And we tried to do some kind of adjustment on the way we do the appointments. Since that decision, the way we do appointments is that we strictly consider that the sole arbitrator or the presiding arbitrator must be of a different nationality from one of the parties, unless otherwise agreed by the parties in the contract. So we have to make sure that really that's strictly controlled and managed by the center when it comes to appoint a sole arbitrator or the presiding arbitrator of an international commercial dispute. So to do so, we have prepared kind of guiding documents that supplement our rules, and most of those supplement documents are really supplement Article 16 of the Kigali International Arbitration Rules. And those guiding documents are what we call the statement of acceptance that is applicable to most arbitral institutions, the statement of acceptance, availability, impartiality, and independence, to be read and signed by the appointed sole arbitrator or presiding arbitrator. So there is also what we call, we used to have it, notes to arbitrators. So, but we amended it in 2024 to make sure that it addresses the issue that really promotes the neutrality and impartiality and of the sole arbitrator and the presiding arbitrator, but also the code of conduct that each arbitrator has to read and sign. So those guiding documents aim at calling arbitrators to reinforce their duty of independence and impartiality, while they encourage the tribunal to promote a more robust management of proceedings to ensure the integrity of the process, of course, respecting the party autonomy. So through our notes to arbitrators and definitely in accordance with the law establishing the Kigali International Arbitration Centre, and specifically Article 17 of our constitution, or establishing the centre. So we encourage, the tribunals are expressly encouraged to invite parties to explore settlement at each level arbitral proceedings. So that's also another way of really encouraging the tribunal to manage proactively and not just to just hear and receive the party submission, because in some cases that we receive here, we may get the power imbalance between the parties. So one may be very strongly represented and another one may be weakly represented. So when arbitrator acts in that way, he gives or she gives chances to both parties to explore avenues to find a fair kind of decision. So I think that is the approach that we've adopted to make sure that the arbitral tribunal act in a proactive role instead of staying passive. But we are here to hear from other colleagues, maybe to hear some other approaches that we may use to make sure that those criticisms are not raised again on African Arbitration Centre. Thank you.
Thank you, Victor. That's helpful. It's very interesting to see that the ability of arbitrators to take a proactive role in proceedings is being favoured, and that's obviously in the interest of justice. Let me first turn to Guilaume from the perspective of the Swiss Arbitration Centre, because obviously Victor mentioned that there's the general rule which most institutions have, that the arbitrator should be of a different nationality as one of the parties. But that wasn't the problem in PNID. They were of different nationality, but they were seen as Western against the African. That's the perception that was created. So how does your institution deal with that expectation?
Well, Switzerland has a reputation for neutrality, and I think the centre would see it as a failure if the party were to think that it will not get a fair hearing before they even step in the arbitration room. One of the ways the issue is addressed is that as court members of the Swiss Arbitration Centre, we've had a full day of diversity training, simply to make sure that everyone recognizes that everyone has a tendency to try and appoint people they know and stay in their comfort zone. And the idea was to try and explore ways of breaking outside this and making sure that there was sufficient diversity in the appointments. Then the other one is that I have seen personally as a court member, I'm not saying my fellow court members have had the same experience, but cases where the usual shackles of appointments that are applicable law and seats, and which normally pretty much determine who in which pool you're going to select. Well, these have been, there were concessions made in order that the presiding arbitrator be someone who can be seen as neutral and impartial by all the parties, including freedom from cultural bias.
Excellent. Thank you very much. It's reassuring. Henk, any thoughts on this point about, from perhaps the CIArb perspective?
Well, thank you very much. So what we find ourselves in a unique position with CIArb again, in that any appointments that go through London, head office, goes into the President's panel, which is populated by chartered arbitrators. And then we have, in the African context, we have our own branches who also now follow appointing processes. And we have on our branch lists of arbitrators, both chartered arbitrators and fellows. And what we do in the onboarding process is we ask the market what they want. And we have the proper defining of the dispute, and then we allow the parties to tell us what is the arbitrator that they want, in terms of qualification, in terms of knowledge, in terms of skill sets, whether it should be a fellow, whether it should be a chartered arbitrator, or where it fits in the scheme. And then we try and deal with the appointment on that basis. And if I don't have an arbitrator in South Africa that complies with it, I phone my colleagues in Zambia or in Nigeria, and I say to them, this is what I need, what do you have? So we have diversity across the whole African spectrum, and we're now also starting with the process of wanting to do that with adjudicators. So once we determine that, what we give the parties also is the option, tell me if you want 3 arbitrators and their CVs, and I'll provide that to you. And you can choose someone from that group. If you can't, between the parties, choose someone from that group, I will appoint someone from that group for you, and it's an open, transparent process, and the parties know what they want. So we comply with the IBA processes, all the conflict disclosures are made. If there are any, the parties require neutral people. We give them that. We give them people from different jurisdictions, different colors, different races, different everything. And we want the parties to tell us and guide us so that they are satisfied and they have a clear understanding of who and what they're going to get.
Well, that's extremely helpful. And perhaps, and this is dialogue amongst institutions, and I think this is an extremely helpful approach, because no one can complain after they've been given the chance to say what to explain what their expectations are in terms of appointment. And that's very good practice, an established practice. And personally, I have started seeing that in the context of Russian sanctions. And Russian parties are saying, well, sorry, we don't want anyone from a country that has sanctioned Russia. Fair enough. So they're starting to express their expectations when arbitration rules of institutions typically don't provide for that. And perhaps that should be the next step. Ask the parties in their request, what attributes, what qualities, what backgrounds are you looking at? But very, very helpful, and CIArb can certainly assist because you have years of experience doing that. This is just amazing. This dialogue is coming up with so many solutions, which really shows that there should be more dialogue. And again, thanks, Svetlana, for setting up this panel. Let me move on swiftly to another key question, since we're in Africa, and I will ask Karim first. Karim, are institutions starting to depart from established practice that arbitrators cannot be African in international arbitration?
Yes, that's the main question that everyone wants to answer to. Quick answer, yes, absolutely. Being mindful of the time, I would just provide statistics. So over the last 5 years, the number of appointments of African arbitrators has more than doubled with the PCA, and I think that it's a trend across any arbitrating institutions, so it's a very positive signal. Then another statistic, 85% of those appointments are related to contract-based disputes, which means that we still have some work to do on investment state arbitration. It is, again, a changing or an evolving trend, but we have work to do. And finally, we mentioned the issue of neutrality, and I will maybe talk more about this afterwards, but it's also now a request from parties, and therefore, African arbitrators are more relevant when it comes to neutrality.
Thank you, Karim. Let me ask Henry for his perspective on this question.
Thank you. I want to say that sometimes you have to then consider how did we get here to a place where we can even ask such a question for international arbitration, especially in the continent of Africa. And one has to then think about the colonial and post-colonial legacy and the reality within which we live in, and begin to address those concerns. The second thing I want to say is that we have to see, for example, in investment arbitration, what are states doing? What are they doing to in determining who's going to represent them in their international arbitrations? Or when they have a choice to pick an arbitrator, who do they pick? And I think that has always been an indictment for the African states. And then there's therefore need to address this concern with finality, so that then the numbers can then begin to shift, and we can see a change in that. To answer your question directly, for NCIA, what we have seen is a healthy panel of arbitrators who are in the African continent and a few from outside the continent. And our practice has been, for at least the domestic cases, we make sure that we are trying to, we are appointing arbitrators who are mainly African. So I'd say 95% of the appointments will go to Africans, so that then helps in terms of answering the question that there is a shift in that direction. For international arbitrations, the consideration is the same, that we want to consider parties, or rather arbitrators in our panel, who then automatically will be chosen from the list, African arbitrators. That's what I want to say in addition to what the others have said. Thank you.
Thank you very much, Henry. Guilaume, may I trouble you with another question? Because obviously, to be able to appoint diverse panels, you need diverse courts or institutional appointing bodies. So do you think there has been a move, or there should be a move to further diversify courts so that they can bring arbitrators from different parts of the world?
Well, I think there certainly is. And first of all, I should say that despite what it may look like, I am in fact a diversity appointment on the Swiss Arbitration Court. In that I'm in fact French and not Swiss. Now you may say that's not throwing the stone very far, but in fact the Swiss Arbitration Centre has taken steps to diversify the court in recent years, and there are court members who are or work in countries such as South Korea, Turkey. There are court members in Dubai, in Paris, in London. So there is a real push towards diversity in the court. And we also, of course, have Zelda Hunter, a South African who is practicing in Geneva as a member of the court. And unfortunately, I cannot say today that we have a court member practicing in South Africa, but perhaps in the future.
Thank you, Guilaume. Henk, what are your thoughts about the courts? I know CIArb doesn't have a court as such, but what are your views?
Well, I mean, unfortunately, we sit with the issue of subconscious bias. And that which you see in the morning when you look in the mirror is what you want to deal with and appoint. So there has to be a specific decision to deal with diversity and appoint people from diverse backgrounds. And you're going to get that and approach that so much easier if your court or the panel of appointment are people of diverse backgrounds in terms of whichever diversity you seek. So absolutely important, and we need to get away from subconscious bias.
Thank you, Henk. one final question on this, on the PNID issue and the credibility of international arbitration. Since we're all together and we're talking about cooperation, is there room for cooperation between arbitral institutions or other institutions from Africa and beyond in different parts of the world for at least, you know, for the appointing institution to be able, to be enabled to achieve the perception of neutrality expected in appointing sole or presiding arbitrators? Karim did hint that he would be addressing this, so I'll start with Karim.
Absolutely. So yes, there is now also a change in terms of perception and therefore room for cooperation. Here I'd like to highlight a recent cooperation agreement that was entered into between the Shanghai Arbitration Centre, known as SAC, and the African Society of International Law. This initiative really was very novel because it created a new expectation in terms of arbitral appointment. And I will read now Article 1.2, which says that to promote neutrality, independence, and diversity of arbitral tribunals, the African Society agrees to recommend distinguished legal experts and practitioners for consideration as arbitrator in SAC-administered cases, in particular for cases involving non-African parties, which means that the African Society shall recommend African practitioners and African legal experts to ensure neutrality. And as an example of this, even if we haven't seen the implementation of such article, but I'd like to refer to PCA case 2024-42, which is the Federation of Russia as a respondent against Wintershall. The case is the second one in this saga. And the appointing authority had to appoint the presiding arbitrator. And as Jamsheed mentioned, for neutrality purposes and as requested by Russia, it has to be an arbitrator with a nationality of a country that has no sanction against Russia. The appointing authority appointed Funkwe Adekoya, a Nigerian national, to ensure neutrality. Therefore, this is why I said previously that African arbitrators are more relevant when it comes to neutrality. And I will end here.
Very, very interesting, Karim. The MOU to establish the principle and the practice as done at the PCA level definitely tends to promote African arbitrators in non-African disputes, East-West disputes. They are very neutral. It makes sense. It's very logical. I think that it's good that this is now being realized, you know, and put in practice. I will also ask Aleksei to give us his views on this point before moving to a last question. Please, Aleksei, but please, very briefly, please.
Yes, thank you, Jamsheed. I think that there is really certainly room for cooperation. For instance, Belarusian authorities are actively developing business connections with African states. And just in last year, official meetings were held with officials from more than 10 African states. And thus, all these connections will result in business contracts with arbitration clauses, obviously. And having arbitrators from African states on our recommended list is extremely important for us to build trust and credibility in our arbitration institution among African business circles. So in this regard, we would be happy to consider a possibility to sign in an MOU and exchange arbitrators with every arbitral institution taking part in today's discussion. Thank you.
Thank you, Aleksei. I suspect, because Svetlana has indicated that we were given less time than we had been promised. So perhaps we'll have a few more minutes.
I just don't know. Let's confirm that. Did we have 75 minutes or 60? 75.
So we'll take very few moments just to complete, because we cannot leave this panel without, this session without addressing this very important topic. So, because we are talking about diversity and neutrality and credibility, what about gender diversity? SOA's recent survey still shows that it's not being implemented properly. There are various excuses, that are being given. For instance, cannot identify suitably qualified candidates, etc. So diversity is, gender diversity is obviously something that goes to the heart of credibility and ethics as well, because I do not see this ethical to discriminate, and institutions should not. And parties as well, of course. And I will ask some very brief final comments from the institutional perspective as to what is being done concretely. And may I start with Dalia?
Thank you. To be very brief, I think institutions are doing very well on that specific issue, because our CRCICA rules and other rules provide that when the institution makes the selection, it should take into consideration nationality, but also diversity aspects. A very quick look at the ICA cross-institutional task force on gender diversity shows that, I'm not going through the number for the sake of time, but at least for the 2024, you have 37.7% of women appointments made by institutions, 30% by co-arbitrators, and 20% by the parties. So I think we're asking the good question to the wrong people. I think institutions are doing great effort on this, providing for a list of arbitrators full of very competent women. I think the problem lies within the parties, the council, and broader cultural problems and perceptions. Also, one of the problems are looking for qualified women. I think this goes within a broader question of access to education, perception, the language, the translation of the language of the AFSA rules give me the idea of language is a barrier to inclusion and to diversity, because if you judge people by their accent, you judge that, okay, she didn't receive a good education only by her accent, while broadening the spectrum of the language could also bring in more competent people. Men and women, by the way, not only women.
Yes, yes, indeed. No, these are very, very useful comments, and you have seen this from the institutional perspective and experience. Okay, so maybe a very last point by Svetlana on gender diversity from AFSA's perspective.
So everyone knows that this is something that is very close to me, but I'm happy, especially you also see here in Joe our support. But let's talk about the appointment now, about the woman in the arbitration, and especially the institutional side of that. So from AFSA side, we really taking this very seriously, and we are seeing great progress. And I'm not saying that as marketing exercise, I'm speaking with the numbers and the stats that I'm seeing every day. And but before I also share some of the numbers, we make a difference between party appointment and the institutional appointment. And the struggle is of the party appointment. That means we need to push more on the ground of the legal community to also start thinking with us, because what is from what we have for the last 2 years, this is the stats that I look. So we have 99% party appointments. And I cannot say that we achieve some gender diversity, although that we make the nomination as per our policy and regulation. But for the appointments that court do, there is 100% diversity, 100% woman nomination. So also from international rule perspective, The court is who appoint, not the secretariat. But again, the numbers speak by itself. We have the diversity on the institutional side, but not on the party side, on our user side. And this opened the biggest gap and show us where we need to work and to change that mindset.
Thank you, Svetlana. I think your centers don't need to justify because of your own presence here and the recent appointment of Liz Bosman at the, as president of the court. So, but I hope that this has convinced not only the audience but the panel, and that was really the idea behind from Svetlana, that there must be this type of dialogue regularly to find ways and means to help together enhance the credibility and the practice of international arbitration. And on this, I will thank the audience for your patience and ask the audience to join me in congratulating this amazing panel for their immense contribution. Thank you, John.